So we're just waiting for one attorney who's out in the parking lot, should be up any minute now before we start.
And is Mr. Cohen coming?
No, he's going to be on the phone.
Oh, okay, great.
He was going to come in person, but he was at the stars of the room.
Would like to say hello.
It's so funny, so he and I are sitting on the large electoral board together. And then I'm representing an objector, I think I'm representing an objector in another board that he's sitting on. And then here I'm sitting with the electoral person. Such a small world.
Did you get everybody's names? That's the Alderman, Jose Ramirez, R-A-M-I-R-E-Z. He's the
No,
candidate.
not him, the attorney that's going to say.
Oh, Pericles Abbasi.
A-B-B-A-S-I.
Thank you.
A-B-B-A-S-I. So two B's, A-S-I.
And the last name?
That's his last
his
name.
No, what is first name?
Pericles.
P-E-R-I-C-L-E-S. So Mary, I got great news from my mom today.
Yeah, what?
She got her scan result.
Yeah.
No signs of malignancy.
Beautiful,
And fighting lung cancer.
Oh, great.
beautiful.
That's great.
Well, they were giving my mom the vaccination even though she had the COVID.
I didn't know your mom got COVID.
She got COVID in the home. She came out completely okay, but they gave her the vaccination. They're giving her the vaccination too, so.
You fight a health issue on that.
She turned 87 in
Oh,
November.
wow.
Yeah.
God bless,
Yeah.
yeah.
That's awesome. And she obviously did okay with the COVID.
Yeah, I spoke to her because you can't see her.
Yeah,
Spoke to her several times and she seemed like she was doing okay. She just wasn't eating
yeah.
and she was tired. That was it.
You know, it affects people so differently.
Yeah.
You know, my neighbor across the street, she got it, and she's about my age, about my build, you know, not anything overly unhealthy or anything like that. And yeah, I was walking out front one day because I saw like something going on with some ambulances, and she was being carted away in an ambulance.
Oh,
Yeah, and it just affects people differently. You get a 17-year-old who's having heart just died a couple weeks ago.
Yeah.
Over something with an 18-year-old and the wind. Doesn't seem to be someone having phone. Yeah.
My mic's on. Yeah, as soon as the other attorney comes in, I'll have them all. Yeah, we're just chatting, so I'll have them all turn it on as soon as they come in. Yeah. Yeah, that's fine.
Hey, Chris, we're here with the Electoral Board. We're still waiting on, one of the attorneys to come, but I wanted to get you on the line so we're ready to go.
Thank you. Is this number one that if somehow we got cut off, call back down to 2660?
No, that's,
No, just if you get cut off, just text me or call my cell phone, and I'll call you back. So, do you have my cell phone? Okay, I'll email it to you just in case, because I don't want to broadcast over Facebook.
Oh, I see, okay.
Yeah, because you're on speaker right now, so the whole room can hear you, and we are broadcasting it via Facebook Live, so, yeah.
Well, I'm impressed with your skill at being able to do that.
It's not my skill. It's the tech people here at Berwyn, but we will extend your kudos.
Yes, please extend them to them. I'd like to know how to do that myself.
And Chris, I just emailed you my cell phone number, so you should have it, just in case something happens.
Thank you.
No problem.
Very smart spot that issue.
Yes, that was a good call.
We are waiting for objectors' counsel.
Correct.
Can I say hello to the other two board members there?
Yes. You got Mayor Lavero here,
hello?
and we've also got Alderman Avila.
Hi, how are you?
Hello. Hi, Alderman, how are you?
Very well, thank you.
And then we've got the candidate Alderman Ramirez. And now Objectors Council just walked in the room, so we'll, go ahead and get settled real quick, and as soon as all the parties are ready to go, we'll go.
Yeah, and I apologize for being late. I got a phone into another electoral board hearing in North Utica.
Oh, boy.
I'll let me start Friday.
I'm not hearing the Alderman.
Yeah.
Well,
If I could remind everybody to turn on their microphones, just push it once, you should get the green light. You have to do it for the phone and for yourself too, Tim,
Got it.
okay? Okay.
Everybody ready?
Can Mr. Cohen hear us then?
Can you hear everybody, Mr. Cohen?
Yes.
Okay.
Okay,
I heard that voice just then, yes. It's a little, in the back, like when you're at a television studio and the person has the mic somewhere way far away, but I heard it.
can't put it any closer. Okay, so we're going to call to order the Municipal Officers Electoral Board of the City of Berwyn. January 13, 2021, approximately 5:40 p.m. So we need a roll call. Mayor Lavero is the chairman here.
Alderman Avila, present.
Public member?
This is Chris Cohen, I'm here.
Mr. Christopher Cohen has been appointed by the court as the public member of the board, and he is attending by phone. Also present with us is the board attorney, Tiffany Nelson-Jaworski. Present is the objector's attorney, Pericles Abassi. The candidate's attorney, Mr. Michael Dorff. And the candidate is also present, Mr. Jose Ramirez. So it's my understanding, gentlemen, that we have pending for tonight a motion to dismiss and the response. It's also my understanding that there were several stipulations made prior to tonight between council. So could you just spell the stipulations out for the board so we know what is not going to be presented?
Mayor, before we do that, just one quick housekeeping
Sure.
matter. I would like to add to the exhibit list, actually, I do need that document real quick. I would like to add to the exhibit list and Exhibit H, which will be the order from the Cook County Circuit Court appointing Christopher Cohen as a public member.
Okay.
So can I have a motion to add that to the?
Motion to add that exhibit, appointing the public member. All those in favor?
Aye.
Avila, aye. Lavillo,
Aye.
aye. Cohen,
Aye.
Okay, roll
So
call
ordered.
taken, all of it, motion carries.
So if I can ask to please enunciate what the stipulations were, so we know what we'll be hearing then?
And if the candidates could speak loudly and into the microphone, or I'm sorry, not the candidates, the attorneys, if you could speak loudly and into the microphone so we can make sure that the public member who is attending via telephone can hear. Thank you.
Yes, so.
Thank you.
The first thing is, the first item I'll mention is the objector is withdrawing the allegations in paragraph 7 and paragraph 8, which have to do with the circulation of the petitions and whether the Mr. Thomas Stebbins was the actual circulator. We're withdrawing those allegations. And so this hearing today, because of the stipulations we're talking about, will become, it won't be an evidentiary hearing. It'll just be a legal hearing on the arguments. And the stipulations that were made are that there are 47 signatures which, where the voter had signed Alderman Ramirez's Democratic petitions, in addition to signing his Progressive Thinker Party petitions. It was also stipulated that the Progressive Thinker Party petitions were not circulated until after Mr. Alderman Ramirez had submitted his Democratic petitions and withdrawn them. One other item I think we should have mentioned is paragraph 5 of the objection. Myself and the Candidates Council, we didn't discuss this, but we had challenged 4 signatures or 4 lines because they were stricken out and had no address on that. Would you stipulate that those are invalid signatures?
Yes, and first, Mr. Cohen, hello. Good to see you again. Yes, we stipulate the lines challenged in paragraph 5 involve lines that were crossed out but had no circulator or candidate initialing, and there was no certificate of deletions. And I appreciate Mr. Abbasi's prudence in asking to strike those on the grounds that without the certificate of deletions, perhaps they might be considered valid signatures. We did not include those in our count, and so we can accept that those lines be stricken.
And so, by my count, and Mr. Dorff can confirm this correct, the candidates' petitions had 72 lines. Subtracting these 4 lines makes it 68 lines. There are 47 signatures in question, where the what we'll be debating is or arguing is that whether or not the election code says they're valid or not. If those 47 signatures are valid, the candidate will have 68 signatures, which is above the minimum of 25. If the 47 signatures are not valid, he'll have 21 signatures, which is below the minimum of 25. And whether he's above or below will determine whether he's on the ballot or off the ballot.
And we concur with that conclusion.
Okay, so that summarizes the stipulations. Do we have those in writing, counsel?
We do not. Would the parties be able to produce something to the board just to show that exactly what the stipulations are? I mean, obviously, we're here today to argue it. You've put your stipulations on the record, but if you guys can boil it down to some sort of written stipulation and send that over just so we have it for the record.
Fine, I think they
That'll be
were
no problem.
contained in the email exchanges we had, but we can put that into a single page.
Okay, I
That'd be great.
appreciate it.
Yes.
Thank you.
Thank you.
So,
I'd like to add to the Electoral Board's council my assent to that, because I really can't hear I hear a lot of words, and I can pick out individual words, but you're too far from this mic for me to hear. But
Can I move this
I
over?
don't need you to repeat it to me or have her repeat it to me if you're going to put it in writing.
Okay. Is it possible for me to move
the phone, here's the cord, so you can move
Yeah,
it
I think
wherever
I
you can
can.
get it.
Let's
I
see.
just don't know.
1 second, Mr. Cohen.
Okay.
All right. 'Cause hearing the parties is probably way more important than hearing.
Yes, hearing the attorneys.
Oh,
Actually, if you want to put it, I don't have another,
Need a chair maybe or something? Right there's good, yeah.
Okay, let's try that. Parties, could you talk? So, we can see if
Attorneys?
Mr. Cohen could hear.
Mr. Cohen, this is Mike Dorf saying hello again.
And Perry,
Yes, how are you?
and it's, and Perry Abbasi also saying hello, Mr. Cohen.
Now, the second voice is a little too far away for me to grasp all of the syllables of it, but as I said, won't have to repeat it for me if you're going to put it in writing, and I'll be able to read it.
I would just ask you speak up a little louder, because, yeah, your voice is a little more muted.
Let me try that again. Mr. Cohen, this is Perry Abbasi, and it's a pleasure to present before you this cycle.
Okay?
Okay. So am I correct in assuming, gentlemen, that if we just argue the motion to dismiss and the response, that would summarize the law and basically address the issues that we would have?
Yes, I think, Arneson, this is purely a question of law at this point. There's no questions of fact.
Counsel?
That's correct, Mr. Chairman. It's purely a legal issue.
Okay, so I would say that we just address the arguments on that motion, and then we could be done from there, correct?
Yes, yeah, I think the motion would be, so the typical order of proof is that first we argue, the motion to dismiss is argued, and since Mr. Dorf is the movant, Mr. Dorf would start off, and then Mr. Abbasi would give his argument, and then Mr. Dorf would be able to close on the motion to dismiss. However, then if the motion to dismiss is then denied, then we go to the hearing phase, which would be would be completely repetitive of everything that was argued beforehand. So if the parties don't mind, we'll kind of let you both try to have the last word in a way, because technically, since it's the objector's burden, the objector should overall have the last word, but you have the last word in your motion to dismiss because you presented the motion. So if it's okay with the board and okay with the parties, kind of just let them make their arguments, give them some reasonable opportunities to respond. If the arguments start to get repetitive, then we'll just
Yes,
cut argument off.
yes.
Does that sound agreeable to the parties?
That's fine.
Okay.
Yes.
All right, so Mr. Dorf, can you start off with you arguing on your motion to dismiss?
Thank you, Mr. Chairman. And first, I would like to thank my friend, Mr. Abbasi, for his courtesy in withdrawing the objections based on the qualifications and eligibility of the circulator. I believe that has saved us about an hour of testimony, and I think we can all be grateful to Mr. Abbasi for that. So the sole remaining question in this objection is a simple issue of law. Can a registered voter who signed Alderman Ramirez's withdrawn petitions as a candidate of the Democratic Party, an established party, in the February 23rd, 2021 primary election, can those voters also sign his petitions as a candidate of the Progressive Thinkers Party, a new party, for the April 6th, 2021 election? And the answer is yes. The voter can sign both petitions. And there is nothing in the election code, which prohibits this type of dual signature. And Mr. Abbasi has cited some statutes and he has cited some cases which relate to restrictions against independent candidacies, not new party candidacies. And in fact, Mr. Abbasi quotes a provision in section 10-2 of the election code regarding new party candidates and says it incorporates the restrictions against independent candidates. I want to quote the provision that Mr. Abbasi put in his response. This provision that says, any such petition shall be filed at the same time and shall be subject to the same requirements and to the same provisions in respect to objections thereto and to any hearing or hearings upon such objections that are hereinafter in this Article 10 contained. It is absolutely clear that this provision is talking about the hearings. It's talking about the hearings in 10-8 and in 10-10 and how to file objections. It is not concerned with new party candidacies, because otherwise, when it says any such petition shall be filed at the same time, well, these are filed, established party petitions are filed at one time, new party petitions are filed at other times. And it is also clear that when the General Assembly wants to put in a comparison of restrictions, they know how to do it. Because if we look at section 10-3.1 of the Election Code, which talks about nonpartisan candidates, what does it say? It says, the provisions of this Article 10 relating to independent candidate petition requirements shall apply to nonpartisan petitions to the extent they are not inconsistent with the requirements of other statutes or ordinances. So note this, the General Assembly specifically says you treat nonpartisan candidacies the same way you treat independent candidacies. And in fact, it's because of this provision that candidates for mayor of Chicago and for alderman are subject to that same dual signature restriction. But if the General Assembly had wanted to say that about new party and independents, they could have said it the same way they said it with respect to independent and nonpartisan. And I mentioned in my motion, I know you've read it, so I won't go too deep in it, but a fundamental axiom of statutory construction, which is affirmed by the Illinois Supreme Court, is this Latin phrase, expressio unius est exclusio alterius. And I teach this to my college students, and I love this expression because it's so you can translate it by yourself without even knowing Latin. Expressio unius est exclusio alterius. Expressio, the expression, unius, of one thing, est is exclusio, the exclusion, alterius, of other things. The expression of one thing is the exclusion of other things. And what the Illinois Supreme Court, as I quoted in my brief, has interpreted this to mean is that if the legislature puts in a series of restrictions, then if something is not included, it is not restricted. And I mentioned in my brief the many places where the General Assembly in the Election Code has listed specific restrictions on candidacy, whether you can be a candidate for both an independent candidate and an established party, on circulation, whether you can circulate for two different parties, on whether you can sign more than one in independent candidacies and in nonpartisan candidacies. They do not say anything in the Election Code about whether a new party candidate signer is restricted from after having signed an established party petition. The other thing which I think is also dispositive, and it's the one thing that Mr. Abbasi's brief did not mention at all, was my citation and argument about the case of Rudd versus Lake County Electoral Board, 2016 IL 2nd 160649. And this is a case which is very close, almost exactly on point with our situation. In Rudd versus Lake County Electoral Board, and you may have seen this in the paper because it got some publicity. You had Thomas Rudd was coroner in Lake County, and Thomas Rudd filed petitions as a Democrat. Those petitions ended up getting challenged, and so Mr. Rudd withdrew his petitions. Here we have a situation where Alderman Ramirez filed petitions as a Democratic candidate. Those petitions were challenged, and just like Mr. Rudd, prior to a finding, he withdrew the petitions. So what did Mr. Rudd do? Mr. Rudd decided he would run as an independent. And that was challenged because in Section 7-43 of the Election Code, there's a specific prohibition about running both as an established party candidate and as an independent. And what the court does is they say, you know, he cannot run as an independent, but he could have run as a new party candidate because there's no restriction against running as an established candidate, withdrawing, and then running as a new party candidate. And the court goes into the reasoning about why new parties are fundamentally different from established parties and fundamentally different from independent candidacies. It says, in fact, they say that the court says that Section 743 does not disqualify new party candidates on the same basis as independents, can be seen as encouraging the post-primary formation of alternative political parties by voters and candidates who may be either dissatisfied with the status quo or disappointed with the results of the primary. So here we have a situation where the courts specifically said that you can be a candidate who filed petitions as an established party, withdrew those petitions, and then ran as a new party candidate. And in fact, and I compliment Mr. Abbasi, there was no challenge in the objection to Alderman Ramirez's running as a candidate of the Progressive Thinkers Party, a new party, because this case is so clear. Now, then to argue, whereas we know, while running for office is a privilege, voting and being a petition signer is a right. And so to say that you can have a higher restriction standard for voters, for signers of petitions, than you have for candidates makes no sense at all. And in fact, as I also mentioned in the motion, the State Board of Elections specifically adopts this interpretation. And in their 2021 Candidates Guide, the excerpt I attached to my motion, it specifically says, a signer may sign the petitions of one established political party for the consolidated primary election, which is what these signers did when they signed the Democratic Party petitions, and one new political party, which is what they did when they signed Alderman Ramirez's petitions as the Progressive Thinkers Party, a new political party. I think it is clear. Number one, there is no restriction in the election code that covers this situation. Number two, in the case law that has looked at this, it has been made clear that new political parties are in a different status than independent candidacies with respect to candidacies, and by clear reasoning, it has to apply also to the petition signers, as confirmed by the Illinois Appellate Court, as confirmed by the State Board of Elections. So I respectfully request that this board grant my motion to dismiss and confirm the candidacy of Alderman Ramirez as a candidate of a new political party for the 2nd Ward Alderman in the April election. I thank you for your consideration.
Can I ask one question? Do we have anything in the filings that shows the filing of the new political party?
I don't know if,
Well, he said he filed a new political party. I don't see anything here that shows when he filed or if he actually filed a new political party, other than him saying he's the Thinkers Progressive Party.
It's really, all they have to do is draft a petition that says that they're creating a new political party, get enough signatures, and that's really all they have to do. They don't even have to do this new political party form. It's encouraged, but it's optional.
So nothing has to be filed with the State Board of Election for a new political
No,
party?
No, that's for campaign finances, finance purposes, yes.
That's it?
But
Okay.
yeah, as it relates to anything else, no.
Okay. I'm sorry, Counsel. Go
No,
ahead.
thank you.
And thank you.
I had a question too, if I may.
Yes, Mr. Cohen.
I can't tell if I'm interrupting the other public member or not because I can't see anybody, but if it's appropriate, Mr. Mayor, I'd like to ask this question to Mr. Dorr.
Yes, sir, go ahead.
I see on the sheet, in his, I see in the motion to dismiss that there is this page from the Illinois State Board of Elections Campaign Guide 2021. And I see on the second page, there's the front page, and then there's the second page. It says, B as in boy, a signer may sign the petitions of one established political party for the consolidated primary election and one new political party or independent for the subsequent consolidated election. And then I see a citation of the statute. And I looked at the statute. I don't see where the ISBE's point is made in the statute. Maybe I'm missing it, but if you could show me in the statute where it says that, I'd be glad to consider it.
No, what we believe the Board of Elections did is they did the same interpretation based on the reasoning that I just gave.
I see. All right. So
But
they're
no,
not saying that-
it is not black letter in that statute.
And just for the edification of the board, there's, in addition to the citations that Mr. Dorff had offered, citation for section 10-3, where it talks about, I'm sorry, my microphone wasn't on, I apologize. So just to repeat what I had stated for the benefit of the public, section 10-3, and these are, I'm just going to recite some of the sections where it talks about the dual signing and dual candidacy, if you will. Section 10-3 of the Illinois Election Code states, and this is about at the end of the first extremely long paragraph, it states, and each voter may subscribe to one nomination, and each voter may subscribe to one nomination for such office to be filled, and no more. So that is the section that was cited by Mr. Bassi. It goes on to state, provided that the name of any candidate whose name may appear in any other place upon the ballot shall not be so added by petition for the same office. Okay, so that's...
Counsel, can you help me find that? I have the statute of 10-3 in front of me.
Yeah, so it's at the end of the first paragraph. It's the,
And
so if you just,
the first paragraph I have ends with the words ballot shall not be so added by petition for the same office.
right, just look right above that. It starts off with, and each voter may subscribe.
And then is it, what you're citing is after that or before that?
No. If you look right above where you just talked about, it says, and each voter may subscribe.
Yes, I see that.
Okay, so
the
that's what I
sentence
just
you're
read
saying.
into the record.
Each voter may subscribe to one nomination for such office to be filed, and no more.
Yes. So,
And if I can jump in before Mr. Bassi, just to continue to respond to your question, Mr. Cohen, and we've argued in our brief, and I think it's clear from reading it, that section 10-3 involves the restrictions and requirements for independent candidates, while 10-2 involves the requirements for new party candidates.
yes, the title of section 10-3 does state nomination of independent candidates, not candidates of any political party. So then if you look at also section 10-4, it states at the end, and I just want the board to be aware of all the different types of disqualifications, I suppose. And this is in the last few lines of section 10-4. It states that no person shall circulate or certify petitions for candidates of more than one political party or for an independent candidate or candidates in addition to one political party. So I think what the State Board of Elections did was they looked at these two, they looked at section 7-43, and they looked at the case law, and they came up with what they believe to be the interpretation. So that's, I think, what Mr. Dorff was saying. Is that what you're?
That's an excellent recap. Thank you.
So yeah, but I mean, there is, there is a prohibition. It's just a matter of what that prohibition actually means. And as we all know, the State Board of Elections, they do put that disclaimer on there that it's not legal advice, but that is their interpretation of the law. So
Well,
the
we'll-
board.
We'll be getting most of that information when you do your board memo.
Yes.
So let's let Mr. Abbasi argue his response to the motion to dismiss at this point.
Yeah, yes,
I
and,
want to thank you, Mayor, for that suggestion.
You're welcome.
Thank you.
thank you, Mr. Chairman, and thank you, Mr. Dorff, for his vigorous arguments in support of his motion. So let's start with the statute, which the board council has just read, and I'll repeat. Section 10.3 of the Election Code states that each voter signing a nomination paper shall add to his signature his place of residence, and each voter may subscribe to one nomination for such office to be filled and no more. That sentence is very clear. For each office, a voter may subscribe to one nomination. In the present case, the 47 voters in question had signed for the Democratic nomination and then subsequently signed for the Progressive Thinkers Party nomination in violation of the election code. And I, in my objection, I had cited the case of Watkins versus Burke, which states that the one signed first is the one that counts. The subsequent one doesn't count. In this case, the Progressive Thinkers Party nomination doesn't count. Mr. Dorff, or the candidate, excuse me, argues that this does not apply to new political parties because it is in Section 10-3, not Section 10-2. However, as I pointed out in my response, Section 10-2 contains this provision. Any such provision, or excuse me, any such petition shall be filed at the same time and shall be subject to the same requirements and to the same provisions in respect to objections thereto and to any hearing or hearings upon such objections that hereinafter in Article 10 in this Article 10 contained in regard to the nomination of any candidate or candidates by petition. Mr. Dorff says that what the key phrase for our purposes here is shall be subject to the same requirements. Mr. Or the candidate, excuse me, argues that that this means requirements of objections. However, this is a three-part sentence, and it contains three items. One, the petition shall be filed at the same time. And I'll note the candidate had said, well, it's not filed at the same time as as established party petitions, but it clearly says in this sentence that that are hereinafter in this Article 10. So new or established parties are governed by Article 7. They have the Article 7 filing period. This is referring to hereinafter in Article 10. The first part of this is they shall be filed at the same time. That's part one. Part two, they shall be subject to the same requirements. And part three is subject to the same provisions in respect to objections. So we have these petitions filed at the same time, same requirements, and same provisions regarding objections. And in this is hereinafter in Article 10. And 10.3 is hereinafter in Article 10 from Section 10.2. And 10.3 contains a provision in question that voters shall sign one nomination and no more. So looking at Section 10 itself, we see that expressio unius est exclusio ulterius really favors the objector in this case. Because if you look through Section 10, at the beginning of Section 10, it explicitly says when provisions of Section 10 apply to independent candidates versus those times that it applies to all Article 10 candidates. It says at the beginning, or it says throughout, nominations of independent candidates for public office in any district or political subdivision less than the state may be made by nomination papers, and it says a signature of 5% to 8% or 50 more. It says, however, when the minimum signature requirement for an independent candidate petition for a district or subdivision shall exceed the minimum number for an independent candidate statewide, it says for the first election following redistricting of congressional districts, nominations for an independent candidate for congressman. It says nomination papers for a independent candidate for state representative shall be signed by at least 1,500 qualified voters. So it's explicit when something at 10.3 is applying to independent candidates, it says independent candidate. However, in the section at question, it just says each voter signing a nomination paper shall add to his signature in place of residence, and each voter may subscribe to one nomination for such office to be filled and no more. It does not say one independent nomination and no more. And there are other parts of Section 10.3 that similarly do not restrict itself to independent candidates. Afterwards, it contains the procedures for striking signatures. It doesn't say that this only applies to independent candidates. It just says the person circulating a petition or the candidate on behalf of a petition to circulate it may strike any signature from the petition provided that, and it has 1, 2, 3, 4. It does not say this is for independent candidates. It just says this applies to petitions. And because of that, the provision I cited in 10.2, that the same requirements here and after in Article 10 apply to new party candidates, such as Alderman Ramirez, had he followed these procedures to strike the signatures, they would be stricken. Additionally, there's also, it mentions the case of governor and lieutenant governor. And I should say that striking the signatures does not appear anywhere else in the election code. This, in Article 10, excuse me, this is for new party or independent candidates. This is the procedure to strike signatures because it does not restrict itself to independent candidates. Similarly, it says for the office of governor and lieutenant governor, a joint petition, including one candidate for each office, must be filed. It doesn't say for independent candidates for governor and lieutenant governor, because this provision applies to all Article 10 candidates, which are new party candidates and independent candidates. So because the General Assembly many times in 10.3 specifically says independent candidates for Congress, independent candidates for statewide office, independent candidates for state representative, they know how in Section 10.3 to say this applies only to independent candidates. And for the provision in question, each voter may subscribe to one nomination. They did not restrict that to independent candidates. So because of that, this provision in 10.3 applies just as much to new party candidates as it does to independent candidates. He had mentioned again 10-3.1. Again, that's a case where the General Assembly is specifically saying nonpartisan candidates do the same thing as independent candidates. So that means that the signature requirements, which Article 10.3, it goes into saying these are specific to independent candidates. That's a case where the General Assembly is specifically saying independents have this way, nonpartisans have this way, new parties have this way. But in the provision at question, they did not specify this is only for independent candidates. So it is for all candidates under Article 10, which again is new party and independent candidates. I'll address the Rudd versus Lake County Electoral Board. The provision in question there is Section 7-43 of the Election Code, which says a person who filed a statement of candidacy for a partisan office is a qualified primary voter of an established political party, or which, that's similar to Mr. Ramirez's case, or who voted in the ballot of an established political party at a general primary election may not file a statement of candidacy as a candidate of a different established political party or as an independent candidate for a partisan office in the next general election. So again, the General Assembly specifically said, these are the things you can't do. It specifically said you cannot file as an independent candidate. You cannot file as a different established party candidate. So you can't be a Democrat and then file as a Republican in the same cycle. Again, they specifically said these are the two cases. In the section in question, just as they could have specifically said, you may not sign for more than one independent candidate nomination. They did not say that. They said you may not subscribe to more than one nomination. So the canons of statutory construction, given that the General Assembly knew how to say many times over, this specifically applies to independents, this specifically applies to new party candidates, excuse me, this specifically applies to nonpartisan candidates, this specifically applies to established party candidates. They did not say that in this provision. So it applies to new parties as well as it does to independents. The next item is the candidates guide. I included an excerpt from the candidates guide in my attached to my motion, or excuse me, my response, which is the preface. And in bold letters in the preface, it says legal information contained in this guide is not binding and should not be construed as legal advice or sufficient argument in response to an objection to any candidate's nominating papers. And that's what the candidate is doing here, trying to use it as legal arguments when, again, the code doesn't say that. No appellate court precedent says what the State Board of Elections is saying. So it's not applicable, and it should not be considered as persuasive to this Electoral Board. And I cited, the section that the candidate cited of the election code. It says for both new parties. I included a couple examples of electoral boards differing from the State Board of Election in their position, because it says a signer may sign the petitions of one, excuse me, established party for the consolidated primary election, and one new political party or independent for the subsequent consolidated election. So they're saying, this quote says it's okay to sign for an established party and then an independent one, or an established and a nonpartisan, or excuse me, and a new party. However, in the case, I included two electoral boards that said no, you can't sign for a Democrat in both cases, and then for an independent. I included the Berwyn Township, a decision of the Berwyn Township Electoral Board from 2017. Kaveden was the candidate. The decision which I included was Miguel Garcia versus Alan J. Al Kaveden, and Kaveden is spelled Kveton. And in the decision on page 5, the Berwyn Township Officers Electoral Board found that per 10 ILCS 5/10-3 of the election code, a voter may not sign for an independent candidate and also a party candidate in the same election cycle. So they differed from the interpretation of the State Board of Elections, because again, that's not binding precedent. That's not in the code direct. That's not explicit in the code, and it's not, no appellate court or no has found that. I also cited what the Calumet City Electoral Board had done in the case of Wilson versus Municipal Officers, excuse me, Electoral Board for the city of Calumet City, where that electoral board, again, they found that when voters had signed for a Democrat and then for an independent, those signatures would not count for the independent. The appellate court in that case did not decide on that issue because they had found the candidate was already under the number on other issues. So the State Board of Elections should not be, because they explicitly say this is not binding precedent. This shouldn't be used by candidates in response to an objection. So to summarize, the election code is clear. It says a voter may subscribe to one nomination and no more. In these cases, the voters subscribed to the Democratic nomination for the same office for second ward alderman. In this case, it happened to be the same candidate, Alderman Ramirez. and then subsequently signed for the Progressive Thinkers Party. In that case, they violated this provision of the election code. This provision of the election code applies to new party candidates because of the provision I mentioned, or I cited in 10.2, that the same requirements hereinafter in Article 10 apply to new party candidates. And again, I've pointed out, if in the examples used, in the example 743, in the Rudd case cited by the candidates, in that case, the General Assembly knew how to specifically say, if you run as established, or if you submit nomination papers for an established party or vote in the primary, you can't run for an independent, as an independent, or as the different established party. They specifically said those two cases, and they specifically left out new parties. In this case, they did not specifically say independent. It includes all it includes all candidacies. And even 10.3, they know when to say, this is what applies to independent candidates. This is what applies to all candidates. So for that reason, this section 10.3, that voters may subscribe to one nomination, means that these 47 signatures in question are invalid under the election code and must be stricken, and the candidate's motion to dismiss must be denied. And then subsequently, with these signatures stricken, the candidate will have fewer than 25 signatures and may not be placed on the ballot. Excuse me. And that's my argument. Thank you.
Mr. Dorff?
Thank you, Mr. Chairman. I wish that Dorothy...
Could I ask a question?
Yes, Mr. Cohen.
I'm sorry, I can't tell if I'm cutting somebody off. I hope not. Mr. Abbasi, could you help me with section 10-4, 10-4, with the last sentence in it, and tell me whether 10-4 and the sentence are relevant, and if they are relevant, what this means to you. At the bottom of 10-4 says, provided further that no person shall circulate or certify petitions for candidates of more than one political party, and it goes on. What is the significance of that from your point of view? And when Mr. Dorff's time comes, maybe he'll address that also.
It's not particularly applicable here. That deals with circulators. We're talking about voters. I mean, if the General Assembly can set different requirements for circulators and for voters, and I believe that section has differences between a consolidated cycle and an even year cycle. I don't have it in front of me. I just
Okay,
printed
so it
out
doesn't
10.
apply. That's fine. Okay.
Yeah, no, yeah. I think that deals with that does deal with circulators. That doesn't deal with signers, which is we had an allegation with regard to circulators, but that was withdrawn.
Mr. Dorff, did you want to answer Mr.
Yes,
Cohen's question?
yeah. Mr. Cohen, thank you for your question. I think it is absolutely relevant because it explains, again, that the General Assembly knows what it's putting into the statute. And when they want to refer to independent candidates with respect to restrictions, they know how to do that. When they want to refer to candidates with different restrictions for established party and independent candidacies, they know how to do that. And I think that supports my argument that if the General Assembly had wanted to make the specific distinction between new party signers and independent signers and established party signers, they would have done it. And I only wish that Dorothy Sparks, who was my high school Latin teacher at Roosevelt High School in Albany Park, was here to see me arguing with the distinguished counsel over a Latin phrase. And to the meaning of that phrase. I will only briefly, I think we.
If I can just do a quick, I'm sorry. If I can just, a quick follow-up, because I think that, this may help the board understand 10.4 a little bit more. It does state that no person shall circulate or certify petitions for candidates of more than one political party. It doesn't say one established political party, and it doesn't say one new political, so it says one political party. So it's still, at least in my read, it's still foreclosing somebody to just one party. So whether it's, it's basically saying somebody can't circulate for a Democratic candidate, and then they cannot also circulate for a new party candidate.
And that-
And I think that, I just want to make sure that, everybody understands the one political party, that does include new political parties.
Absolutely, and I'm glad you brought that up, because I mean, it's absolutely clear. When the General Assembly wants to refer to all political parties, they do it. There are places, though, where they only refer to established political parties, and there are places where they only refer to new political parties. They understand what they are writing. And if you take Mr. Bossi's argument to its logical extreme, when he says that everything in Section 10-3 applies to Section 10-2, well, then we would have the same signature requirements. And we don't have that. We have very different signature requirements for new parties, which is a 5% one, as opposed to independent candidates, which is a 5% to 8% one.
Well,
There-
just to be clear, that the Section 10-3 actually states nominations of independent candidates for public office within any district, and it goes on, and then it states the signature requirement.
Right,
So it actually does, it
exact-
specifies, so I think that actually goes to.
No, it's exactly, because what Mr. Abbasi was saying, in reading that one line of Section 10-2, the line that says that the petitions in 10-2 are subject to the same requirements and to the same provisions, and he's saying that means you have to apply the 10-3 double signer restriction. And I'm saying, if you were going to apply that, then why aren't you applying everything else that's in that section? Because it doesn't specify it. And that's why I think the only reasonable reading of the line that Mr. Abbasi is relying on in 10-2 is that this is in respect to objections thereto and any hearings upon such objections. With respect to using the guide, we have not argued that the guide is precedent. We have said that the Rudd versus Lake County is precedent. We have not declared estoppel or any of the things with respect to the election guide, because as we all know, the election forms put out by the State Board of Elections cannot be relied on for estoppel purposes. But what it does show is that the reasonable interpretation of the Rudd case with the election code is the interpretation that we have made. The Berwyn case that Mr. Abbasi has cited involves independent candidates. Watkins v. Burke involved signers of Democratic and Republican petitions in the days when aldermen ran in primaries. There is no case that he has cited that refers to new parties. And again, Mr. Abbasi just sort of passes along on the part of the Rudd case where, yes, it involved 7-43, and the Rudd case specifically said that you couldn't be an independent candidate if you had filed Democratic petitions. But then it went ahead and said, but you could have done it as a new party because new parties were not specified in the restrictions. And that's what we're saying. New parties are not specified in any of these restrictions that the objector wants to impose upon us. So again, I think that our reading of 10-2 is correct. Our interpretation of the precedent of the Rudd case, I think, is absolute. And the Rudd case really goes philosophically as to why new parties are just different than other things. And so, again, we request that you accept our motion to dismiss.
If I can ask a question on the Rudd case. The appellate court held that Rudd could not run as an independent.
Yes, sir.
That section that says, but could have run as a candidate, is that not dicta? Is it to be considered precedent?
That is a great legal method question. They did not, I think you would probably have to say yes, it is dicta rather than holding. It is hard, though, to argue that a voter has fewer rights than a candidate in the same situation.
I'm sorry, I interrupted you. Is there anything else you wanted to add, sir?
Very quick, let me just take a quick look at my notes if I may, sir.
Mm-hmm.
No, that's it. Thank you, Mr. Chairman.
Okay. Mr. Abbasi, is there anything you wish to add?
Yeah, just in a, I guess, a reply. The reason the signature requirements in 10.3 don't apply to new party candidates is because they explicitly say independent candidates have this signature requirement. If you look through this long first paragraph of 10.3, it'll say independent candidates for statewide office have this signature requirement. Independent candidates for subdivisions less than the state have this signature requirement. After redistricting, independent candidates for state representative have this requirement. Independent candidates for Congress have this requirement. That doesn't apply to 10.2 because it specifically says this is for independent candidates. But the provision in question does not say independent candidates. It says each voter may subscribe to one nomination for such office to be filled and no more. If it only meant to apply to independent candidates, it would have said independent candidate, just like every other all these signature requirements in 10.3. If 10.3 were thought to be, if it said at the top, this is only independent candidates, then the candidate would have an argument. However, it doesn't say that, and that's why it explicitly says when it applies to only independent candidates. So that's why those provisions of 10.3 don't apply to new party, because it specifically says this is independent candidates. And going back to Rudd, with that in mind, Section 7-43, which Rudd interprets, explicitly says that if you turned in nomination papers for an established party, you can't run for another established party or for an independent as an independent. And it leaves out new political parties. That's why that's a different situation. This line, just what we're interpreting here, doesn't parse this out. Is to, okay, established party, new party, independent. It just says each voter may subscribe to one nomination for such office to be filled and no more. The office to be filled here is Second Ward Alderman of the city of Berwyn. These voters subscribe to the Democratic nomination. Therefore, they cannot legally sign for the Progressive Thinker Party nomination, and therefore these 47 signatures are not valid. And if the General Assembly, as the candidates, Mr. Dorfit, as the candidates council, Mr. Dorfit said, the General Assembly knows what it's doing and it knows what it's saying. It could have said independent voters may not sign for more than one independent nomination, but they didn't. They just said more than one nomination. And clearly in all these other cases and places in Section 10.3, they say independent candidates have to get this many signatures. But they didn't qualify that here. It's just clear, one nomination. And since these 47 voters had signed for a Democratic nomination, they may not sign for the Progressive Thinkers Party nomination.
Okay, Mr. Cohen, did you have any other questions?
I'd just like him to respond to the question that you asked about whether it's dicta.
Mr. Dorf did explain. Would you explain again, sir?
Yes, yes.
No, I was asking Abbasi. You asked, he
Oh,
answered.
I'm sorry.
Mr. Dorf answered, but I didn't hear Mr. Abbasi's answer to that.
Would you respond to that question, sir?
Yeah, yes, I mean, that part is dicta because it, the question at hand in Rudd was he had signed, or he filed nomination papers as a Democrat, he withdrew them, then he ran as an
Okay.
independent, and Section 743 says you can't run as an independent or a different established party.
So if I understand it, both of you are saying that which is dicta.
Yes, I agree.
Thank you.
Any other questions, Mr. Cohen?
I have one which hasn't been raised, but I'd rather hear the last things that Mr. Dorf was going to say.
Well, I don't need a sir reply. I think
Yeah, I think that,
we've argued it.
yeah, if I may.
Thank you, Mr. Cohen.
Yeah, Mr. Cohen, I
Then
think
I'd
that,
like-
yeah, go ahead with your
I'd
question.
like to raise a question for each one of them. You don't have it in front of you, but I need to give you a citation so that and I'll read you a paragraph. The first citation is 238 Illinois 2nd 674. And the case name is Stephen Rosenzweig, Rosenzweig versus Hebda, Cynthia Hebda, Hebda. It's a 20 case. And then the Supreme Court sent this back to the appellate court, and here's the appellate court case citation. It's called Rosenzweig versus Illinois State Board of Elections. And the citation is 946 Northeast 2nd 1113. And maybe it's not relevant because you agreed about the signature, but I'm going to read you a sentence, and it's something that is puzzling me. The last sentence, the last paragraph in the entire decision says, for the foregoing reasons, we hold that the remaining restriction in Section 8-8 of the Election Code prohibits signing a nominating petition for a candidate from one political party and then running as a candidate for another political party in the same election cycle. Now, I know neither of you have had that before, but to me, it's relevant, unless the facts are different. If he didn't sign a petition in the first case for the Democrats, this might not apply. But he did he not?
Who are you referring by he did?
I'm sorry, your pardon, thank you. The candidate, did the candidate sign a nominating petition for himself as a Democrat? Did he sign a petition sheet?
Gentlemen, correct me if I'm wrong, but I believe he did.
Well, actually, that would have been an interesting question if we had taken it. My understanding is that an invalid statement of candidacy had been signed as a Democrat, and I think that was the basis of the challenge. So it's sort of an interesting legal point as to whether an unsigned statement of candidacy is actually a statement of candidacy. Fortunately, that is not in front of us right now.
Well, that wasn't this case. This case was one where the person, Hebda, went into a grocery store and signed a petition for somebody running for state rep. And it happened to be a Democrat. And then a week later, they came to her and said, Hebda, you great candidate. Why don't you run as a Republican? And she did. So my question was, the one that the mayor just asked there was, did this candidate sign a nominating petition, not the statement of candidacy, but did he sign a petition sheet
I see.
for himself for Democrat?
That's a factual question. I don't know the answer to that, sir. I will say that in our brief, in our motion, we refer to Section 8-8, which specifically says that a qualified primary elector of a party may not sign petitions for or be a candidate in the primary of more than one party. And again, that refers to established parties, because new parties do not have primaries. And as we said in our brief, that I believe that makes the Rosenzweig case inapplicable because it is not the same cycle. It is, and 8.8 specifically talks about not signing petitions for or being a candidate in the primary of more than one party.
Well, I see that point. I didn't see it before. I appreciate your mentioning that. Am I correct? Could I ask counsel here, is that true that a new political party would never, under no circumstances, ever have a primary?
That's correct, because as Ms. Jaworski mentioned earlier, the only way you create a new political party is by filing a petitions with a slate, and that or a single person, and there is no primary for that party.
And just to be clear, a new political party can become an established political party if they get enough votes, and then they file petitions in the following election cycle.
In the subsequent one,
In
yes.
subsequent, correct.
Okay. Does Mr. Abbasi have some response to this particular thing? I realize that neither of you had it in front of you.
Yeah, I mean, I don't have it in front of me, and I'm not sure if the candidate had signed his own petitions. His Democratic petitions were included as an attachment to my objection, but I didn't bring them with me because we
Well, perhaps
stipulated.
Perhaps it was not objected to. So my question means that this is not relevant here then, because you didn't make that objection.
Yeah, I'm going through the original petitions filed, and I do not see the candidate's signature on the Democratic petitions that were filed.
And
I might be
I would
on-
agree with Mr. Cohen that since this, as we all know, objections cannot be amended once they're filed, and no objection was made to that specific signature. And I know it was not on the 48 signatures that Mr. Abbasi, that the objector listed as being duplicated.
He circulated all his own petitions on the Democrat. I did not see his signature on there. I think that what Mr. Cohen cited would be applicable had he signed, but I did not see his signature on any of the petitions that are here. And he circulated them all. It would have been crossed off even if he had signed it.
Thank you. You answered my question. I just would like to point out, it sounds like I don't have that this doesn't apply, but the reason I gave you two cases is the 2010 case was the Supreme Court sending this back and ordering the appellate court to reverse it. So this is not just an appellate court decision. But anyway, thank you, and
Okay.
I appreciate, Mr. Mayor, your raising that point and telling me. I'm done.
And, okay, Alderman Avila, you have any questions?
No questions whatsoever. The council articulated their, responses very well. Thank you very much.
And I have no questions. At this point, I'm looking to the board attorney for what scheduling orders we would need here.
Yes, so, just for the edification of the two litigants and the public, the board members have separately asked me to prepare a board memo, because this is obviously a novel issue. This is not an easy matter, so I will be preparing a memorandum to the board to summarize the law that's been stated by the parties and to, potentially give a recommendation, but mostly it's going to be a summarization of the law. So I will be preparing that, and then we just need to schedule to come back here for the board to issue a written decision, we'll continue deliberations and potentially issue a written decision. So we can go ahead and get that scheduled.
I have to get my calendar.
Okay.
Could I ask counsel for the board while we're doing that?
Yes.
The deadline is the 28th, but we have to be done well before that, am I not correct?
Well, we got to try and get it done as quickly as possible, so that, you know, the parties can have, you know, their rights to appeal should they wish.
Okay.
Obviously, you know, I'm going to need some time to draft the memo, and so tomorrow's not going to work, and Friday I am booked up. I would say probably sometime next week. Is daytime at all possible?
Depending on the
For me,
day.
Chris Cohen.
Yeah, it depends on the day for me.
And to the members of the other members of the board? I was thinking maybe Tuesday during the day. I've got a hearing at 4 p.m. and a hearing at 5 p.m. and a hearing at 6:30 p.m. on Tuesday. And then Wednesday, I've got hearings going from possibly 10 a.m. until 5 p.m., but it depends on Mr. Cohen when the Norwich hearings get set. So
Yeah,
still don't know about that.
right.
Um,
I have a
so,
Bloom Township at 10 a.m. on the 20th.
yes. Yeah, so if the parties are available Tuesday during the day, that could, I could do that.
Is
Does
that
it?
giving you sufficient time to do the memorandum?
That should give me sufficient time to do the memorandum and
'Cause-
get that to the board.
Just for purposes of at least giving you sufficient time, I have Thursday completely open.
I'm completely wide open Thursday.
Is
Yeah,
that
me too.
Thursday, the 21st?
Yeah.
Thursday the
That's fine.
21st?
Yes, that's,
Okay,
That's
then
perfect,
let's do that, and then we could do 5:30 so that Mr. Ramirez could be here, because I know that he works a day job, and I know it's difficult to
so.
get off, so,
Is that fine, Jose? Thursday the 21st, 5:30?
okay.
Perry?
That's fine with me.
Mr. Cohen, that's fine for you?
Yes, sir.
Okay, then the last item that I have is public comments. I believe our board attorney has 2 public comments to read.
I do. Let me just grab those.
Mm-hmm.
Just bear with me one moment, I'm sorry. Seems I printed things up and I cannot locate them now. Okay, I will read the, oh, here we go. Okay, the first public comment was submitted to me on Monday, January 11th, 2021, at 10:30 p.m. And I think the person thought I was a man for some reason because they called me Mr. Jaworski, so I'll just read it into the record.
I'm sorry, Mr. Mayor, could you ask her to move a little closer to the
Oh,
microphone?
sorry, I was just making a joke.
A side comment.
So it says, Mr. Jaworski, Jose Ramirez has been my alderman, and I would like a chance to vote for him. I understand he often votes against what the mayor wants. That is what is at the bottom of this effort to get him thrown off the ballot by challenging his petitions. It is petty and should not succeed. I resent the attempt to keep a good man off the ballot for partisan reasons. I want this to be read into the record at the upcoming meeting. And again, that was submitted by Patricia Ramos at 10:30 p.m. on Monday, January 11th. And then shortly before the hearing, at 4:54 p.m. today, I received a second public comment from an individual named Kim Cohen, K-O-I-N, and she stated, as a resident of the 2nd Ward of Berwyn, I would like a choice as to who my alderman is. Please withdraw all objections to Jose Ramirez running and allow all 2nd Ward residents to make a decision for themselves who should represent our ward as alderman. Mr. Mayor, those are all the public comments that I received.
Okay, and there's no other public members here, so Alderman, did you want to make a comment as a member of the public? Alderman Ramirez?
Yeah, I mean, again, I guess we have a minute to say.
Yeah, probably do it into the microphone so that the
Sure.
Facebook Live could catch you.
So, I guess, you know, this is very interesting. I've never been to something like this before, and hope I never do again. Politics, you know, is one thing, and democracy is another. And I feel, you know, here we should look at democracy. You know, what is best for the people of Berwyn, for the second ward? You can cite and you can look and you can find, you know, I'm listening to both lawyers and you know, they both had good points. But I think in the end, if we do what's right for the voters, I think that's what counts. And so I just want to say that, you know, I want to thank everybody for their time. I know this is not easy on everybody. And so, thanks.
Okay, thank you. So no other public comments. I would ask for a motion then to adjourn.
To recess,
moved.
actually, to recess.
Oh, to recess, I'm
Yes.
sorry. A motion to recess, my mistake.
So moved.
Moved by Avila,
Second.
second by Cohen. All those in favor, Mr. Cohen?
Aye.
Avila? And Lavero, aye. Thank you, everybody.
Thank you.
Thank you.
Thank you, Mr. Chairman.
And I'll get you guys the board memo in advance.
Yes, please.
21st.
Is that next Thursday?
Yeah, next Thursday.
Anything else from now?
And book it, please.
Okay.
So to turn off the mic, push it till it turns red.
No, not at this point. And it really depends on what the
Yeah.
parties choose.